Your Honor, Laura Baluch on behalf of Melissa Slife, who is present.
Good morning, Your Honor. Patty Hall on behalf of Michael Slife. He is not present this morning.
Okay, and we are here for discussion of a petition for temporary relief that was filed by Attorney Hall on behalf of her client, seeking an order directing the immediate listing and sale of the marital residence. Is that correct?
Well, actually, Judge, we're here on my client's petition for temporary relief for support.
Ah,
Counsel did file a petition for temporary relief seeking that as well. We have filed a motion to dismiss that. I would assume that she's going to want an opportunity to respond to that.
well, and I had in my calendar that we were here for argument on that if you couldn't work it out. So I guess we cannot work it out.
Well, Judge, I did get the motion to dismiss, and I think it was filed this on Wednesday. So I would like to respond to it, but it is my argument, and I'll talk about it a little bit today. But I think that the marital residence issue kind of goes with this support issue and the party's finances at this time. So that's kind of why I wanted to address both when we first came in front of you on this case. But I realized that we may not be doing that today.
Yeah, Judge, I think what we really need to address is the support issue. Just taking a look at the financial affidavits, Mr. Slife should be paying my client $3,782.25 per month in maintenance. So we would be asking for an order on that today. Council's filed this petition to sell the marital residence. I have a motion to dismiss. There's case law that indicates that the court cannot order that unless it's by agreement while the case is pending. But we can get into that later on. But the support nonetheless is something I think that is absolutely warranted and something that should be granted.
Okay, well, I'm just going to briefly say on the marital residence issue that the way that the court could determine after hearing whether the marital residence should be sold or not sold, that the mistake is just ordering it when one party objects and the other party wants it without more. And that said, my thought is, since it clearly is an asset and it's definitely going to impact the support issue one way or another, that I'm going to just enter and continue that motion, but give Attorney Hall an opportunity, like 28 days, to file a written response. Okay, I just don't want to dismiss it. I don't want to decide it, but I don't want to dismiss it either. Okay?
Understood.
Understood, Judge.
Now, on the issue of maintenance and looking at the financial affidavits, I think it's kind of important to understand what, if anything, Mr. Slife is already paying that would or should stop if we enter a support order.
So, Judge, and that's my client's position here. We're aware this is a long-term marriage. It's a permanent maintenance case. We're not here saying, oh, we want to, avoid maintenance. It's the timing and the practicality. Right now, they have a joint account. Mrs. Slife is not working. I understand she earns some farm income from a farm that is, I think, a non-marital asset, or I think that's where we're going with it. it's modest. So even if you impute like a minimum wage, she does have some skills and some ability to work. I understand. Maintenance is not going to cover what the housing expenses are on her side. And right now, the expenses are coming out of that joint account where Mr. Slife's income goes. So he's covering living expenses for Mrs.
He's paying
Slife.
the mortgage. Is he paying the mortgage right
He's pay,
now?
he's paying for everything right now. So out of that joint account, like I said,
Insurance and
his own rent and his own living expenses. They don't have a lot of debt, luckily, in this case, so that's helped. But his net income covering both living expenses is just enough right now, and then either imposing maintenance on top of that so that they can maintain the mortgage, or taking away the payments he's making, separating the finances, and then expecting a $3,700 maintenance payment, as Attorney Belush is saying the amount would be, isn't going to cover those expenses. The expenses listed on her financial affidavit are almost $6,000. So I think that maintaining the status quo, allowing the parties, putting in place a non-dissipation, non-transfer, in order, just explicitly providing that they maintain the status quo while we work out the finances. We don't have any parenting issues in this case, so would really be best for the marital estate. Otherwise, we're looking at possibly depleting savings and other assets that the estate has right now that is really not necessary.
Attorney Belush.
Judge, I think what you have is a case where when you have a party who doesn't want to pay the amount of the maintenance, of course, my client will have to pay the expenses of where she's located, but she doesn't have any income. They have a family farm. She has done work around the house and done work with regards to that throughout the entire marriage. So to say she's just not working isn't accurate. She does. She just works and he gets all of the money for that. So this is a case where
Explain that one.
because it's a family farm. So he's claiming all of the income from that. And so it's just a situation where she's been working on at that.
Non-marital asset.
No.
Buckle up, guys. Today we are diving straight into a high-stakes courtroom showdown. The case kicks off with attorneys laying out their positions, immediately framing a clash between temporary support and the potential sale of the marital home. Tension builds as both sides hint at conflicting priorities, with the judge listening closely. Even in these opening moments, you can feel the stakes. This isn't just about numbers, it's about control, fairness, and setting the tone for what comes next. Every word matters here.
There's more to this case than that, Judge. And so I realize there's a lot that has to go into it. But if you just take a look at what the financial affidavits show, that amount of maintenance, and look at my client's financial affidavit and what she indicates the expenses are. I mean, the mortgage and for the home where she's at is $1,757 a month. She can afford that.
But her living expenses, she's claiming, are over $5,900. So a maintenance payment of $3,700, even if we agreed that was the amount, isn't going to cover that. And then we again are running the risk of, or do we go into the marital savings? They have extensive investments and savings, and are we then depleting
Patty,
the
if you're
estate?
indicating that he's going to continue to deposit 100% of his paychecks into the joint account, and my client is able to take as much money out of that as needed in order to maintain her financial affidavit, I think she would do that.
Well, and this is why, Judge, my client's request to list the marital residence for sale kind of goes with this, because we have extensive expenses where one person doesn't necessarily need that. And we're not arguing that today, but that's a substantial asset and something an expense that could be reduced at this point.
And my client sees that as a way to try to control her and to try to let her know that she can't live in the home that she wants to live into. We don't do that. And the reason why the courts have indicated that you don't do that and say that a house should be sold during the marriage is because at the end of this, there are going to be a lot of assets that we're going to divide. So to say that she can't afford this house right now is just way too premature to do.
The risk judges, we order maintenance if that's what the court would like to do. I would be asking obviously for minimum wage at least to be imputed on Mrs. Life to calculate maintenance because she is employable. So we would need some calculations based on that amount.
How long were they married?
20, let me pull
Long
this.
time.
Like 26 years. Does that sound right?
Long time, Judge. And she has not worked. And so to say that we should impute income at minimum wage to her right now when she has not worked throughout for a very, very, very long time.
She has held part-time jobs. She's
And she
worked
does
different
work
jobs,
around the
Judge.
home and the family farm. She does those types of things. And to say now that she has to impute minimum wage would be absolutely inappropriate.
Well, the
Okay.
family farm is in
Okay,
Kansas, so
stop,
she's not
stop,
working at
stop,
the family
stop,
farm on a
stop.
regular basis.
Nobody can hear me, right? Okay, here's what I did. I have used his financial affidavit, and if that's correct, his income for this year is going to be roughly $117,000. Does that sound correct?
He makes about 155, at least what's reported. But again, some of that is farm income and some of it is interest and dividend income. So, but from his wages, it's about let me pull that up a second.
So his financial affidavit is incorrect then, since he didn't list all sources of income.
Well, he listed the dividend and interest income on there, Judge. But that's something that the parties share.
Well, and Judge, and that's the thing, when we get into the discovery, we're going to find out, and when we calculate the temporary support on a stand-up argument, you have to go off of the financial affidavits because we don't have any additional discovery at this point.
And
So
he
I
has,
do anticipate we'll get into it
Okay.
more and those numbers will change.
And Attorney Belush, what's the number you're looking for?
Judge, my calculation comes to $3,782.25.
And what are you using for his annual income?
I used, let me go to my worksheet here, just based on what his financial affidavit showed. So I used his gross wages of $14,903 per month.
All right, guys, now we see the heat turning up as the discussion zeroes in on support versus the marital residence. The attorneys spar over who should pay what, and the judge probes for clarity. Financials and household dynamics take center stage, highlighting how intertwined money and living arrangements are in this case. You can practically sense the tension in the room as each side tries to assert leverage. These moments set the framework for the complex arguments ahead, and every line foreshadows the battle over control of assets.
We used a joint filing, tax filing status in 2026 because that is
comes
what
to
they will end up doing.
$178,000 a year.
That is based on his financial affidavit, yeah.
and like I said, Judge, that nearly 2,000 of that is interest and dividend income monthly, 2,000 monthly that we've divided out from the parties' dividend and interest income.
How much income did you impute to your client?
Judge, I didn't impute any income to my client because my client doesn't have any income. She does not have a single dime.
She's reported on her financial affidavit some farm income, which my client did not claim because I understand that this farm is something that is in Mrs. Life's
Okay.
claimed
What's the
assets.
annualized or monthly?
I'm sorry, Judge, I didn't hear what you said.
What is that amount annualized or monthly?
On the financial affidavit for Kansas farm income lists 35,434 gross receipts and 19,335 for ordinary necessary expenses.
Yeah, Judge, but I don't
20
believe that this
grand.
is actual income that she receives.
Well, what is it then?
Melissa, can you answer that question? Oops, I think we might have lost her.
No, she's there. She's trying to unmute, I think.
Can you hear me?
Yes.
Yeah,
Okay, I'm having unstable internet connection, so I'm able to hear part of the procedure, but not everything.
here's the question, ma'am.
Yes,
You put on your financial affidavit $35,000 a year as income from your family's farm.
can I clarify?
Please.
I have in front of me the financials for
She froze.
23, 24, and 25, because those are the years I have been in charge of the farm financials. The 34,433 for 2025 is the farm income before expenses. The expenses involved were $19,334. So the net income is $15,099. So each year is different depending on the crops and the expenses involved.
Okay,
If I can tell you about 24, just to show the difference. In
Go ahead.
2020, I'm sorry.
I just said go ahead.
Okay, thank you. In 2024, $11,036, and the
So
expenses were 22,000. So the net income was a negative.
I got you. I
Thank
got
you.
you. Okay. Well, I get a much different number than what's being thrown out. I will tell you that I used 312 months, which is 26 times 12. But that uses 179 income for Mike or Michael and 15 in income for Mrs. Life, Melissa, and with no children, and I'm not throwing a credit for insurance in there. I don't know what that is. My number is pretty high.
I'm getting 3478, Judge, so I'm not real sure. With the 15,000, adding that in.
You're getting 34 something?
Well, and understand too, in my calculation, I had that $15,000 in there as well.
Buckle up, because now we are deep into the financial labyrinth. Maintenance, joint accounts, and living expenses are dissected with surgical precision. You can see the real suspense here. How can a court balance fairness with practicality when the finances are tangled? The attorneys emphasize the burden on each party, while subtle digs at one another reveal strategy and stakes. It's not just numbers. It's a psychological chess match, with the judge carefully weighing every implication for both parties' futures.
Okay.
I got 3750 without the 15,000. So,
And my number came to 3782.
but I think, Judge, because the farm is in Kansas, it's not a job that's being worked regularly here. I think there's an argument for imputing income on Mrs. Life and expecting that she obtain at least part-time employment because she does have a history of at least working part-time throughout the marriage.
Judge, I don't think that would be
Well,
appropriate to do. I'm sorry.
I was going to say, no, at this point, no motion to either compel employment or demonstrating that all the factors for imputing income has been filed. And I don't even know if you're in a position to argue that at this point, because, the law changed on imputation of income, and I have to make some findings. And we haven't talked about those at all. I.e., is she voluntarily unemployed? Based on what she's telling me, she's at least doing some work in managing the family farms, and to the extent that she's voluntarily employed, we don't have any testimony on what the agreement of the parties was. Is she going to stay home and run the farm while he works? Is she going to, get a job? And she just hasn't. I haven't heard any testimony on that issue. And I'm concerned, Attorney Hall, and this is more a question than anything else. When did these parties file?
Just in, oh God, what date? End of January?
Yeah, it's a 26 case.
Yeah.
So we're not talking a huge arrearage yet. And if I lowball maintenance at this juncture, what's going to happen when we enter a judgment of dissolution and a permanent order? Realistically. So it's a statement, but it's also a question. You understand?
Yeah.
Because this is a decision your client's going to have to make.
Well, I think it sounds like we have similar calculations based on the financial affidavits.
One of you's at 37 and the other one's at 36 something.
No,
35.
3782, 3782 and 3750. Is that right, Patty?
I was at 3750 without that farm income. But with the farm income, I'm at 3478. With him having 175 and them filing joint. And that's without, he does carry the health insurance. And they have 2 kids that are still under their health insurance that are,
Okay.
they're over 18, but they're,
Yeah, I understand. He's paying dependent premiums.
yeah. So he does have that currently, so I'd have to put that in there, which is somewhere on here.
I don't think you get to deduct non-minor children unless are they in college? I
You
can't
get to
recall.
deduct the insurance premiums.
Yeah, for support.
But for maintenance, Judge, it doesn't come into play with maintenance. It comes into play with child support.
I understand. But there's also something you can take into account in maintenance if you're paying for the other spouse's health insurance.
Yeah, actually, if you want to put the numbers in with regards to the support, it lowers his taxable income. So his taxes go down and maintenance probably goes up. But you don't have an actual deduction because you don't get a deduction for your own either from child support. This maintenance.
Right. I understand.
Judge, I think on a stand-up argument, what the court is supposed to do is take it based off of the financial affidavits. And if you take a look at the financial affidavit.
I understand. I'm just trying to see if.
All right, guys, the debate sharpens around contribution, labor, and the farm income. One side highlights the hard work done by Mrs. Slife on the family farm, while the other underscores financial dependency and potential inequities. The tension is palpable as the judge probes, questioning what counts as actual income versus imputed earnings. You can feel the underlying struggle for fairness and recognition. These exchanges reveal how personal effort and financial control collide in dramatic fashion, giving us an intense courtroom narrative.
The first thing I'm trying to do is, given the amount of monthly maintenance we're talking about, we're only a couple $100 apart, right? And so, I feel like I'm going to let Attorney Hall, because I'm not going to run the numbers. I just used an online calculator real quickly. I haven't taken the time to go through the official Illinois family law software maintenance calculator. And I don't want to. I just want Attorney Hall to tell me what her best argument is, understanding that this is going to be a temporary order and that she risks, or her client risks, getting hit with an arrearage when we enter a judgment of dissolution.
Well, and Judge, that was the argument for keeping the status quo right now, and then addressing the sale of the residence, because then the marital expenses are covered. There's no risk of depleting assets, savings. And like I said, this is a financial case. We really need just some, quick discovery. And I think it just makes more sense.
That's not going to fly, especially where she says, once I have the maintenance, I'll pay the mortgage.
Well, if that's the case, then and we start looking at savings being depleted later, then I guess we address it later. We're trying to avoid that situation is what is the concern here. But if we're calculating maintenance, I have family law software pulled up. I have 179 for my client, 15 for Mrs. Life, filing joint, and I'm getting 3478.
Yeah, but you also can't put that in under taxable income either. You have to put it in under wage-like income on farm property because it's taxed differently.
Well, and my inclination is to order support on a temporary basis until further order of court at $3,600 a month, and to indicate that the parties should very carefully monitor that joint account. And what I don't want to see a disaster when we get to judgment of dissolution, or worse, some sort of trial where we have to go through a lot of testimony on what was taken out of the joint account by whom and for what.
Buckle up, because the focus now shifts to precise calculations. The attorneys debate imputed income and maintenance numbers, each side presenting different interpretations of the financial affidavit. Suspense mounts as the court attempts to untangle real versus potential income, with stakes for both parties' financial stability. You can sense the pressure. The judge must decide how far to push expectations for Mrs. Slice's employment, while also ensuring Mr. Slice's contributions are fair. Every figure is more than a number. It's a pivot point in the dispute.
So, Judge, sorry.
Each of the parties is allowed to make expenditures from marital assets for we'll call it the daily costs of living, supporting a household, buying groceries, paying utility bills. All of those things are what it costs you to live. Now, if because he's paying maintenance, there is an agreement that Melissa's going to be paying the mortgage, the property taxes if they're escrowed, the insurance for the house, things like that, then she should not use that checking account to make those payments.
I guess the other thought is my client could just start depositing his wages, direct deposit in a separate account, but I don't know. I think they have their stuff set up automatically, and maybe I'm incorrect, but I think that's coming out of that account.
And I would I don't know what else I can tell you at this point. It's a little bit early for me to start separating accounts or putting either account in a trust or anything like that. Because you don't want to have to come see me every time somebody wants to go grocery shopping or pay you. Among other things. Those things shouldn't be issues. Now, if your client wants to set up a separate account, either of your clients want to set up separate accounts, probably should be done for the maintenance. And if there are ACHs set up for things like the mortgage and that type of stuff, that's going to have to be transferred. Then the joint checking account can be still used for things like clothing, groceries.
Judge, can I ask you, I have an idea. Would it be okay? Could you put me and my client in a breakout room for 1 minute?
Sure, I think I can do that.
Thank you.
Hang on. If I can figure out what I did with the breakout rooms. Here they are. I think every other day, Zoom reformats.
Oh, I know.
All right, guys. Now we hit the climax of the financial showdown. Farm income, net calculations, and maintenance debates dominate as the court considers whether Mrs. Slife's income should be imputed or based strictly on reported earnings. Arguments tighten, stakes rise, and every claim is scrutinized under the microscope. You can feel the suspense as the judge weighs fairness against practicality, teasing the audience with a high-stakes resolution yet to come. It's a tense, riveting look at how complex financial disputes play out in real time.